Welcome back. In this video we're going to be talking about the material in Chapter 20 called Practical Contracts. I happen to like this chapter because it's, as the name implies, it's more practical. These are things that an average person would run into during their lifetime when they are asked to sign contracts. And we sign them all the time. Sometimes they're online when we click I agree to the terms of service or terms of use of a website, or when we're doing things like buying a house or getting a loan from a bank. We find that a lot of the contracts that we encounter are pre-drafted or pre-made and have a lot of standard contract language in them. And so this chapter deals with some of that standard language. We're going to go through and I'm going to explain briefly what some of these things mean. Before we do that, though, I do have our lawyer joke, and it goes like this. There was a busload of lawyers that was traveling down a country road, and it ran off of the road and crashed into a tree in a farmer's field. The farmer happened by the crash. He saw the bus and saw the lawyers there. He proceeded then to dig a big hole and to bury all the lawyers. A few days later, the sheriff happened by and he saw the crash scene. He stopped and talked to the farmer, and he said, well, were they all dead? And the farmer said, well, some of them said they weren't, but you know how lawyers lie. All right, well, let's get started with practical contracts. The first question that comes up sometimes with contracts is, should I write this down? Should I get this in writing? Right? And we know from our discussion earlier that certain kinds of contracts do have to be in writing, but assuming that we have proof of the existence of oral contracts, most oral contracts are fine. So when do we need to get it in writing? As a practical matter, as we go through our day-to-day lives, when do we get contracts in writing? Well, I have a short list here of some things that you might want to consider. Obviously, number one on the list is if the contract is under the category of the statute of frauds. It's one of those six categories of contracts that needs to be in writing to be enforceable. Then you want to put it in writing, right, to satisfy the statute of frauds. Otherwise, you might have an unenforceable oral agreement. But if it's not one of those, if it's also some contract that's crucial to your life or business, I mean, obviously, the more important or significant a contract is, the more proof you want to have that it exists. So a writing will do that. Also, if it's complex, sometimes contracts that we enter into are complicated and complex. They have a lot of conditions associated with them. Those we want to put in writing. Also, if you don't have an ongoing relationship with the party to whom you're contracted, you might want to get it in writing. In other words, if trust is or even might be an issue, it's better just to have an objective piece of proof of your agreement, that writing that you want to have. Okay, and the lawyer. I know there are a lot of jokes made about this, and I make a lot of those jokes, but lawyers are valuable when it comes to contracts, and they do serve certain roles. They can be useful in drafting contracts and in negotiating them. And I have a short list of the circumstances that you might consider using a lawyer. Lawyers can be useful in drafting contracts for the following reasons. Now, this is not a complete list, but just to give you an idea, lawyers are trained to anticipate risks and to specifically try to avoid legal risks. And so when a lawyer drafts a contract, they're usually looking down the road at potential disputes, what will happen if this contract is breached, trying to draft the language to avoid any kind of ambiguities, those kinds of things, with an eye toward eliminating any possible disputes in the future. Also, lawyers tend to negotiate the contentious issues up front. The parties themselves, the parties to the contract, they may be like most people, and human nature is to sort of put off the unpleasant. Lawyers typically, in drafting the contract, and again, because they've been trained to anticipate possible risks popping up or disputes, they tend to tackle the contentious issues right off the bat, get them negotiated, get them fully agreed upon before going any further. This can be a benefit. And then sometimes, honestly, parties that hire lawyers to do contracts sometimes can use the lawyer as what I've called the bad guy. In negotiations, one party may not want to have an unfavorable relationship with the other side, but they do want to negotiate for some pretty tough terms. And so they can rely on their lawyer for this. And they might be able to say things like, well, I'd like to give you this, but my lawyer won't let me. Or I'd like to include that language in the contract, but my lawyer advised against it. And so in that way they can be valuable. What about the contract or contracts themselves? The actual framing of the contract and the wording that's used. Let's take a look at some issues related to that. First issue that might come up is who drafts the contract? I mean, if there's not a pre-printed contract that's going to be used, which party will draft it? Usually, it's the party who has the better bargaining position. Normally, it's the person who has the better bargaining position in the negotiations that will then go ahead and write up or draft at least the first draft of the contract. Okay, so once that's drafted, and once there's a first draft of the contract, how do we read those as non-lawyers or clients? I always tell my clients to read them this way. First, before you even read the draft, think about it. Think about the risks, think about what you want to get out of the contract, the benefits, think about potential disputes down the road. Just think about all the big picture items or issues that come to mind when you think of the contract. Second, read through the first read of the contract, making sure those basic things are present. All right? You want to make sure that obviously none of the big benefits are missing, or if there's a potential risk, you want to make sure that it's covered in there. Also, after the first reading, ask yourself, what if? What if certain things go wrong? What if the other side doesn't do what they promised to do? Is it covered in the contract? Are there liquidated damages provisions, for instance? Have we agreed what will happen if there's a breach? What's the worst case scenario? All those things. Ask yourself, what if? And then, if there are issues, bring those to the lawyer's attention or to the other side's attention. And then when you do your second reading of the contract or final reading, make sure the contract answers those what-if questions. Make sure those things get included into the contract. Our next category here is mistakes. Mistakes are the bane of the lawyer's existence. Lawyers try to read and reread and proofread the contracts to make sure there are no mistakes, but mistakes happen. One mistake might be vagueness. The wording of the contract tends to be vague or unclear. Vagueness sometimes will happen because one party will put in language that is intentionally unclear, leaving open a certain issue or topic. Because number one, maybe they don't want to negotiate that right now with the other side, or maybe they're looking to take advantage of a possible vague term later on so that they can define it as they're performing the contract. This is risky, of course, because this could lead to disagreements, disputes, and ultimately a trip to court. Also, ambiguity. Related to vagueness is ambiguity. Ambiguous words or phrases in contracts, of course, are words where the interpretation is open. It's not clear what certain terms mean or how they're going to be applied. And I've got this old-fashioned term that I've included here called contra preferentum. And this is a doctrine that the courts use when a court is looking at a contract and looking to interpret it. One question that the court will ask itself is, who drafted the contract? Which of the parties drafted the contract? Because this doctrine of contra preferentum says a court will construe, whenever there's ambiguous terms, a court will construe the contract against the drafter. All other things being equal, if the interpretation of a word or phrase comes down to two different meanings and one favors the drafter and one favors the other party, the court will come down on the side of the other party. Right? In other words, the court will kind of presume that the drafter has some responsibility for making the terms clear, and if the drafter of the contract is not clear, then the court will come down in opposition, I guess, to the best interest of the drafter when there's a tie. Okay, continuing on with mistakes. Typos, typographical errors that appear in contracts. We call them, in the law, we call a written error a scrivener's error. Scrivener is a person who used to write or copy contracts and other documents. Sometimes they would make an error. Well, it's the same concept when we go to write down and put into words a party's oral agreement. Sometimes there can be errors, typographical errors, that kind of thing. Remember the remedy of reformation. Courts will sometimes use the reformation equitable remedy to reform a written contract to conform to the party's intention where there's a scrivener's error or a typographical error. What can we do to prevent mistakes? Well, there are some things that we can do. One thing that I would encourage clients or non-lawyers to do is, if you hire a lawyer to do the contract, let your lawyer draft the contract, but you want to be diligent in a few things. First, sometimes lawyers will use standard contracts or contract provisions that they have used in the past that they just kind of continue to use in every contract. But I always tell people, if there's a provision in your contract that you don't need, that's clearly irrelevant to your contract, cut it out. If you don't need it, there's no sense in making the contract unnecessarily long. Second, and this is maybe the most important, if there's a clause or phrase in your contract that you had your lawyer draft for you and you don't understand it, ask. Ask what it means. A good lawyer is a good teacher. And a lawyer will tell you and be able to explain to you in simple terms what this means. Never sign a contract if you don't understand all of the terms. Ask. And then last, make sure you're familiar with the contract itself and its contents. A lot of times people rely on their lawyers not only to draft the contract, but also to know what's in it. Right? Well, I always encourage people to know what's in it themselves, because the contract is the document that's going to govern your relationship with this other party in the future, on into the future as you perform. And if you're not familiar with the contract language, then you're going to be constantly referring to it, and you might be surprised ultimately what's in it. All right, the structure of a contract. A lot of contracts that are drafted, especially by lawyers, have a certain format or a certain structure. And so, generally speaking, I want to run through that structure with you. First, the contract will have a title. The title should be as specific as possible, not just agreement at the top, but if it's an agreement to purchase real estate or real property, it should say agreement to purchase real property, just so that you can tell right away what the intention is right off the top. Next is a lot of times an introductory section where we'll have the names, and sometimes the addresses of the parties to the contract, and it'll contain confirmations of the agreement, and it'll say things like, the parties listed above hereby agree to the following. Sometimes we'll have what I call the whereas statements, and these are basically statements of intention that appear a lot of times at the beginning of a contract. And this is where the parties will state what they intend to happen from the signing of this contract, why they're signing the contract. They'll put their intentions, whereas I believe the following, or whereas the following is true. And these sometimes are valuable if we get into court, for instance, if we get into a dispute and the court questions, well, what were the parties' intentions here? Why were they signing this in the first place? It can kind of create an overarching framework for a court to interpret the contract if they know what the parties' intentions were, because after all, that's the court's job in enforcing a contract, is to enforce the parties' intentions. Also, definitions. Sometimes contracts can be pretty technical and include terms of art, terms that we don't use in everyday language, and so we want to define those. We want to be as precise as we can, again, so that we can eliminate any potential disputes down the road. Then we get into the covenants. Covenants are the promises, right? The covenants are the statements about what each side is going to do. And we want to be specific. We want to use specific language, and a lot of times we want to use the active voice as opposed to the passive voice when we're drafting the contract. One party shall pay to the other, not that something shall be paid. One party will perform. It just makes things a little more clear about who's going to do what. So once we get through all those covenants about who's going to do what, then we want to cover breach if that's possible. We're going to indicate what constitutes a breach. We want to be specific about that. We want to include any conditions that might be included in this or the next section there. Liquidated damages provisions. What will happen if there's a breach? If it's a crucial area and it would be a difficult damage to determine ahead of time, then we might want to agree with the other party right in the language of the contract what will be a breach and what will happen, who will pay what to whom upon a breach. And then conditions, of course, make sure they're conditional promises and not reciprocal promises. I know this doesn't make a lot of difference to most people, but in the contract, a lot of times the parties will be exchanging performances. And what you want to do is make one performance conditioned upon the other side's performance and not reciprocal, so that if the other side doesn't perform, then that relieves you of your obligation to perform your condition. Representations and warranties. Sometimes in a contract there will be a section where it will contain statements of fact as the parties believe them to be at the time of the signing of the contract. And again, this really goes to the parties' intentions and what they believe to be true, but sometimes we want to put these down in the contract so we can kind of capture at that moment what the parties believe to be true. For instance, I have there on the slide, the landlord warrants that the property to be leased is zoned as a rental under the city's zoning ordinance. Because zoning ordinances change from time to time. Cities like to change zoning, and so at the time we sign the contract, it may be good to know that the landlord is promising that as of now it's zoned as other than single family use. It's zoned for rental, that kind of thing. And then what I call the boilerplate. These are the standard contract provisions that make their way into a lot of contracts. You'll see these in pre-printed contracts with the bank, with an insurance company, online. A lot of the retail sellers online will have these terms in them. And so I'll just kind of run through them really quickly and give you a brief explanation of what they are. First, choice of law and choice of forum clauses. These are popular and becoming more popular, especially in online contracts. A choice of law clause in a contract is where the parties agree that in the event of a future dispute, the parties agree to use a certain law to resolve the dispute. The parties are choosing, for instance, to use the law of the state of Illinois to resolve the dispute, or the law of the state of California, or it could be, the law of, a certain province in France. Whatever the parties agree ahead of time, they agree basically to use a certain area or law, code of laws, to resolve their dispute. If that's the case and a dispute comes up, then of course we'll look at that and say, well, they've agreed to use the laws of the state of Illinois, which may be slightly different than other states, for instance, in resolving these kinds of disputes, and the court will apply that law. Also related to that, choice of forum clause. A choice of forum is where the parties choose what place, forum, that they will have their dispute resolved. Right? So if you sign, or you click I agree, I guess, on a lot of the website's terms of use, if you read through there, you're agreeing that if you ever have a dispute with that online seller, whether it's Apple or Amazon.com, a lot of times you're agreeing to have your dispute resolved in California State Court under California state law with the choice of law clause. Right? Why? Because that's where those companies are located. Right? And by clicking I agree, you agree to go there and sue them there if you have to sue them to have your dispute resolved. Also, modifications to contracts. Once we have a contract in writing and we need to change it, make amendments or add things to it or change some of the terms, how do we do that without undoing the entire contract? Well, there are basically three ways we make amendments. One is by signing an amendment. Right? We can actually just add an addendum, or sometimes called a rider, to the contract where the parties make clear this is an amendment to the earlier contract that we signed on a certain day, and then put your change in there and then have everyone sign it again. Or if we don't want to add an entire amendment, we can handwrite the change and initial the changes. We do this in real estate contracts from time to time. Real estate contracts, a lot of times the ones the realtors use are pre-printed, and they'll have certain terms in them. If the parties want to change them or make additions or deletions to them, then a lot of times after we sign the contract, or at the time we're signing the contract, we will strike through the pre-printed term and then handwrite in above it a different term, and then we'll have all the parties make their initials next to the handwritten change. This is, of course, an indication that it's everyone's intention to change the pre-printed form. And so that's one way to modify or change a pre-printed contract. And another way to do it is just to rewrite the whole thing. If we have significant changes or we want to make significant alterations to an existing contract, we can rip it up, and we can, now that we have all these contracts on computer, of course, we could just make the changes, print out a new one, and sign it all over again. And of course, that's another way to make the change. Other just pieces of boilerplate language that make their way into contracts. Some terms on assignments and delegations. Sometimes we don't want the other party to the contract to be able to assign their rights to a third party. Usually, though, we don't want the party to be able to delegate their duties under the contract. And so we'll have some language in there about no assignments or no delegations, or a lot of times both. And the language will read, the parties to this contract agree not to assign their rights or delegate their duties to any third parties. And if we've agreed to that, then the court will take a look at that and usually enforce it. An arbitration clause. This is, again, becoming more popular and very popular with online contracts. If you read through your contract in what I call the boilerplate, now a good place to find the boilerplate language is if you start from the bottom and read backwards. A lot of times these standard contract provisions are at the end of the contract, and they're just kind of listed one after another. Your more substantive provisions that are unique to your specific contract, those usually come at the beginning in the covenants portion. And then we have this boilerplate, which are these sort of standard contract language terms, and they all come at the end, right before the signature line usually. One of those anymore is an arbitration clause. A lot of times contracts or online agreements will contain an arbitration clause that says if there's ever a dispute between the parties to this contract, both parties agree to go through with binding arbitration to have the dispute resolved, rather than going to court. Right? That both or all parties to the contract agree to go to have a private third-party arbitrator hear and make a binding decision about a dispute, rather than going to court, filing a lawsuit, and having litigation. Right? And in most contexts, arbitration clauses are enforceable and binding if all the parties agree to it ahead of time. Oh, attorney's fees. Attorney's fees clauses in contracts are necessary. Make sure you get one in your contract. Basically, the reason that we have to include an attorney's fees clause in a contract is because when parties have a dispute and they end up in court over a contract, typically, without any agreement to the contrary, each side will have to pay their own attorney to represent them in court throughout the dispute, regardless of who's right. And so sometimes what we'll do is we'll put an attorney's fees clause in a contract. This has become standard language. And it will say, for instance, that if there's ever a dispute and the parties end up in court, or even now in an arbitration, or in any way need the assistance of an attorney or legal advice, that the losing party in the dispute agrees to pay for the winning party's attorney's fees. Right? So now we've kind of upped the stakes on any disputes and taking things to court, etc. And what we've done is we said, okay, the losing party will pay not only for their own attorney to prosecute this contract dispute, but also pay for the other side and their attorney. And sometimes you'll read contracts where this attorney's fees clause will be one-sided. Read your lease. If you have a lease, a lot of times the attorney's fees clause will be one-sided in the landlord's favor. Right? Why? Well, because the landlord drafted the contract, right? And they have a better bargaining position. And it'll say something like, if the tenant breaches the lease and the landlord has to sue the tenant, then tenant agrees to pay for the landlord's attorney's fees to do that, if the landlord is successful. So anyway, this is one way for parties to recover the cost of hiring an attorney to prosecute a breach of contract claim and recoup some of that cost. Without the language, though, it's your own expense. An integration clause. We talked about this with parole evidence. A lot of times the contract will include language that says this written agreement is intended to be the final agreement between the parties, and nothing said or done outside of the four corners of this document should be considered in interpreting the document. In other words, this is it, right? We intend for this to be the final and binding agreement, and none of that other parole evidence. Any promises, oral promises made before or at the time we signed this contract, those go away, and we're stuck with what's here in the writing. Severability clause. A lot of times, language in the contract will say, if one clause of this contract is deemed by a court to be unenforceable, that doesn't affect the rest of the contract. The rest of the contract should still be interpreted as being, the party's valid agreement. That's so that if there's one contract or one provision of a contract that's in dispute and a court says, we're not going to enforce that part, then they'll at least enforce the rest of the agreement. A force majeure clause. Sometimes parties will put this clause in a contract to say what circumstances will discharge the parties from the contract. And a lot of times it'll be in the nature of natural disasters, act of God, that kind of thing, where the parties say, in the event of, and they'll usually have a big long laundry list of different circumstances, in the event of a tornado or hurricane or loss of, electricity for a significant period of time, those kinds of things. It will discharge the parties from having to perform. Now, to let you in on a little secret, whether the force majeure clause is in the contract or not, we still have the doctrine of commercial impracticability and commercial impossibility, which might be a defense that could discharge the parties anyway, whether this language is included. But sometimes the force majeure clause is included in there because you want to cover a specific event that could be reasonably unforeseeable, but you want to make sure that it's covered. Notices. Sometimes there'll be language in a contract that describes how one party is to notify the other in the event that certain circumstances occur. A lease is a good one with this, where maybe the tenant wants to renew the lease. And so in the lease itself, it will have some language about what that notice to the landlord must consist of. And a lot of times it'll just require that the notice that the tenant gives the landlord be in writing, for instance, so we can have good proof that the tenant actually exercised an option. Those kinds of things. So we'll be fairly specific about how the parties have to communicate with one another in terms of notices one gives to the other. And then last, our closing. Our closing with our signature block at the bottom. Obviously, if we have a written contract, we want the parties to sign or acknowledge it. We want to make sure that all parties that want to and intend to be bound to the contract sign it. One other thing, too, we haven't talked a lot about this, but if we have a contract that involves a certain business organization, like a corporation that has its own legal existence, we want to make sure that the signature block contains not only the name of the person signing, but their title and their authority, basically, to be signing on behalf of a corporation or a partnership or an LLC or some other business entity. In fact, this is one thing that people need to watch out for. Sometimes with the signature block is, if I'm a representative of a corporation and I want to bind my corporation to the contract, but not myself personally, maybe I'm the CEO or managing partner, whatever, I can sign the contract, but if I don't have my title listed at the bottom and it doesn't reference a corporation, and I just sign my name to it, then I'm personally liable because there's no indication that I'm signing on behalf of another entity. So that's something we want to watch out for there at the closing with the signature block, is we want to make sure everyone's names and titles and their authority is all very clearly stated. And of course, we want to have a date at the bottom. Also, it's always a good idea to have the contract made in duplicate or triplicate, however many parties to the contract there are. Everyone should end up with a copy of the contract, if not an original version of the contract. So we might even want to sign two originals, just so there's no question about who signed what and is this